Good afternoon, dear participants. Welcome to UBLN Academy and to our course Recruitment and Employment. Previously, we had 5 sessions in recruitment, and now we start the second part of our course, and all the next 5 sessions will be with the recruitment topic. I'm very pleased to introduce today our speaker, who is my colleague, Jordan Buckle. He is associate at Gately, and he will talk about employment contracts today.
Great, thank you very much for the warm introduction. So precisely that. So what I'm going to do in a second is I've got a presentation that I will share so you can follow along. There aren't huge amounts of notes, of course. So if you do need any information after this, then do let us know. I'll go through an agenda in a second. To the extent that anyone has questions, there's an opportunity at the end to try and pick those up. I'd be grateful if we kept them related to the subject rather than crazy random employment law, because you might catch me out. If the best way to sort of approach would be if you could put those questions in the chat box, then we can have a look at them at the end and pick those up. So please don't think I'm being rude if I don't respond to it straight away. It's just helpful to go through all the topics and then pick up those questions at the end. So as I say, in a second, I will share my screen, but to give you an idea of what we're going to go through, so I was going to start off with sort of the core elements of UK contracts, then look at where the approach to employment contracts slightly differs from other contracts, and pick up any particular formalities in employment contracts, then talk to you about Section 1 statements. So the Employment Rights Act at the beginning sets out certain information that must be provided to employees and workers. So I'll talk you through what they look like. Then there's a piece on identifying contractual terms, interpreting particular terms, and then the last couple of topics will be where contracts or contractual terms can go wrong, and then particular clauses that employers often wish to rely upon. So as I say, I will now share my screen, and hopefully it's a nice seamless exercise. Perfect. So as explained, if we start with contracts generally, rather than focusing solely on employment, there are certain principles that apply. So in any contract, there must be an intention to create legal relations. There must be an offer and an acceptance. There must also be consideration between the parties. And finally, there must be certainty. So if we pick up on intention to create legal relations first, there must be an intention to create legal relations, and by that, the objective conduct of the parties must be considered when determining the intention, not their subjective states of mind. So to give an employment example of that, of where there is no intention to create legal relations, is the case of a genuine volunteer. So in that scenario, of course, typically in an employment relationship, employee does work, employee gets paid by employer. In a volunteer scenario, that's not the case. So plainly, whether there's a relationship with volunteer, there isn't an intention to create legal relations. Looking at an opposite example is the case of Attrill and Dresner. Now, in that scenario, the employer's argument that its announcement about a bonus pool at a town hall meeting, which was broadcast live on the internet, had not intended to create a legally binding obligation, was rejected. So in that scenario, there was a meeting, it was announced, here's the bonus scheme, here's how it works, la-di-da-di-da. Later then tried to say, no, that wasn't supposed to be legally binding. Now, the court in that noted that it was important that the announcement had been made by the chief executive, so plainly someone with clear authority to offer that bonus. It had been approved by the board, so there'd been some sensible decision making and sign off. It was actually stated to be guaranteed, and most importantly, it had been made with the aim of retaining staff. Similarly, in the employment context, Where a term is being introduced into an existing legally binding relationship, there'll be a strong presumption that it's intended to be legally binding. So if you've got a contract in place and someone brings in a new contractual term, it's going to be really difficult for an employer to say, no, actually, we didn't intend for that to be legally binding. Of course, there is always something to be considered that if there is a work party, the boss gets incredibly drunk and makes an offer, might be difficult trying to make an argument that of course is legally binding. For the offer and acceptance then, so it's probably the case globally, not specific to the UK, but typically in the UK, there will always be an offer letter that comes before the contract, which sets out the headline terms of the proposed employment and also any conditions affecting the acceptance of that offer, such as receiving satisfactory references or a satisfactory medical report. And the wording of the offer will need to be considered, and also whether the offer has been made by someone with the authority to do so. So satisfactory is to be construed subjectively rather than objectively, meaning that relevant checks must be satisfactory to the employer. So if you receive a reference and you consider the reference to be satisfactory, but the employer doesn't, then actually it comes down to whether the employer is satisfied that it is. Offer letters typically will stipulate a time limit for acceptance, after which, if nothing's heard, it will lapse. If there isn't a time limit specified, then it'll generally be taken as to lapse after a reasonable period of time, unless it's very clear that the offer is open-ended, and reasonable in that circumstance depends on the particular circumstances. In terms of accepting an offer then, so it can be accepted in a number of ways, for example, telephone, post, or by email. If an offer is accepted by post, acceptance will be valid when posted. But what about email? Well, that's actually a grey area, as it may be argued that it's when it's read or when it's received by the employer's internet service provider. We are actually still waiting for a clear answer from the courts. So to avoid the issue, typically offer letters should be clear on when acceptance is deemed. Changing terms of the contract unilaterally will also raise issues related to acceptance if it's to the detriment of the employee. Obviously, the opposite of that is if there's a pay rise, that's typically deemed to be accepted, and most employees won't need to say, yes, thank you very much to the pay rise, it would just be accepted. The question will be whether the employee has done anything that indicates acceptance, but it must be something more than just continued employment. And now that's in scenario if there's a detrimental change to the contract. So the example in Abraham and Nottingham City Council was where a 2-year pay freeze was applied when employees continued to work. That did not mean that a contractual entitlement to annual incremental pay progression had been varied. So then consideration and certainty. Obviously, the employment contract, like any other contract in the UK, won't be binding unless there is consideration. In this context, the consideration from the employer is usually payment of a wages or a salary, and the consideration from the employee is usually the provision of labour. In terms of certainty, for a contractual promise to be enforceable, it must be sufficiently certain. And in an obvious example, an agreement to agree will not be contractually binding, even if the parties intended to enter into legal relations. So a couple of examples, Barbev and Eurocom, a letter that provided the employee would receive a 10% share in the business on terms to be agreed was not enforceable. And I think the point there is on terms to be agreed. Clearly, they couldn't form an agreement there because it's essentially we'll figure that bit out later. Similarly, in Allaire and Jackal, telling an employee that they intended to promote them within 2 years was not sufficiently certain to be binding. So then, sort of as alluded to, employment contracts in some ways are slightly unique to other contracts in the UK. And it's important that the interpretation of the rights and obligations will be subject to the same principles that apply to other commercial contracts, but there will be certain exceptions on the basis that they are personal in nature and the fact that the parties do not have an equal bargaining power. So typically an employer will say, here is your contract, and the employee's choice is to take it or leave it. It's only ever really in incredibly senior positions where a senior executive might have an opportunity to say, actually, I'd like these terms changing, but generally they aren't going to be given the opportunity to rewrite the document. So the courts are aware that ultimately an employee has got a limited ability to play around with those terms. In certain circumstances, for example, the description of the individual as self-employed in the contract will be disregarded, and a finding that the individual was an employee or worker with statutory rights. So the point here, and it's a crucial one really, is often contracts might have something written down, but ultimately if the commercial reality is something different, then a court will favour the commercial reality. So often parties will want there to be a self-employed relationship because for one reason or another, it benefits people to have that sort of relationship. But actually, if that individual walks and talks like an employee, then the contract means very little. The inclusion of a right for the individual to provide a substitute so that there's no personal service obligation may be found to be impliedly fettered or not used in practice. And the Uber case law has highlighted the importance of this in practice in recent years, particularly in relation to holiday pay rights. And the enforcement options may also be different in that the courts will not generally order specific performance of an employee contract, i.e. they won't say this term needs one party or the other must perform this particular term when it comes to a party seeking a remedy for breach of contract. Section 236 of the Trade Union and Labour Relations Consolidation Act, or handily called TULRICA, confirms that an employee shall not be compelled to perform work or attend any workplace for the doing of any work, because ultimately it could otherwise be claimed as being tantamount to slavery. You cannot chain a person to a desk and force them to do work. That was an argument that didn't actually work for an employee in the case of Sunrise Brokers and Rogers, in which a highly paid broker wanted to join a competitor without working his notice period. An injunction was sought by the employer, and it was actually granted to keep the contract alive during the notice period. So it didn't mean that the employee actually had to work for that company until the end of the notice period. It simply meant that if he refused to work, he wouldn't be paid, but he was still contractually linked to the old company, so couldn't start a job for the new company. So talking about the formalities then, there actually aren't any. So there are no particular formalities that have to be observed when entering into an employment contract. The contract might be express or implied, oral or in writing. There's no legal requirement for an employee to have a written contract of employment. However, as sort of referenced at the beginning, Section 1 of the Employment Rights Act does require employees and workers to be given a written statement of certain specified employment particulars. And I will go on to go through those with you because it's helpful to jog your minds as to what might go into them. But before that, it's worthwhile mentioning that a Section 1 statement is not necessarily a contract of employment in itself. It might simply be a statement of what has already been agreed orally or in writing, and if there's no separate written contract, the Section 1 statement will be persuasive evidence as to the terms of the contract between the parties. So what does a Section 1 statement need to cover? Again, without sort of touching upon the next slide, generally or broadly, the main terms will be the parties, so the name of the employer and the employee, pay to be paid to the employee, hours of work, where they will do that work, etc. So the fact that there isn't a Section 1 statement doesn't mean there won't be a contract of employment though. An employment contract doesn't need to be in writing and may be expressed or implied. So there's no strict requirement for a contract to be signed. However, it's plainly in the both parties' benefits for it to be a signed written contract because as and when invariably there is a dispute, both parties can go back to the same agreed document and say, here is what the deal was, who's right, who's wrong. It might be inferred that an employer has accepted the terms offered by the employer by their conduct by turning up to work, even if the contract hasn't been signed and returned. It would be more difficult to infer acceptance where new terms are introduced in respect of an existing employee. So this is an issue that often is often asked. So a contract is sent out, the employee begins work, but they haven't signed it. What needs to happen? Does that contract need to then be signed? Can the employee start work without it? Well, the answer is yes, and actually the courts will take on board the fact that if the employee has been given the contract and then started work, by their performance, plainly they accept those terms. Now, of course, if you were to vary somebody's salary down 20% and say, here's a new contract, and they continue to work because they've got no choice, then it would be more difficult in that scenario to say, well, you turned up to work the next day, therefore it must be the case that you've accepted your salary being reduced. So it's not necessarily the contract, but it may be that the written particulars do identify the written terms. So it's not a bad starting point to consider what it has to cover. So Section 1 of the Employment Rights Act 1996 handily sets out the information that must go into the statement of particulars. So those are the names of the employee or worker and the employer, the date on which the employment begins, and any continuous service. So if you change from one employer to the next, and there's a connecting event, so it should state, this contract begins on this day, but your previous employment with X counts towards your service. So actually, you've been employed since X date. The scale or rate of remuneration and the method of calculating that, the method and timing of payment, any terms and conditions that relate to hours, including details of normal working hours, anything in relation to holiday entitlement, including public holidays and holiday pay, and how holiday pay might be calculated on termination. So if an employee were to leave with more holiday or than they've taken, so how that will be calculated and paid, or conversely, if they've taken more than they've accrued, then at what rate that will be deducted from any final salary. Terms relating to sickness and sick pay, terms relating to pensions and the pension scheme, the length of notice that needs to be provided by either party to terminate the contract, a job title or a brief description of duties, the duration of the employment, either that it's intended to be indefinite or if it's fixed term, the end date, any collective agreements that affect this agreement, normal place of work, whether they're required to work outside of the UK for a period of 1 month or more, and see the terms that relate to that, any disciplinary rules that apply to the employment and the procedure and how the employee might go about appealing and to who, whether there's a contracting out certificate in relation to pensions. So that is all Section 1. Now, in April 2020, the government introduced some additional particulars that must also go into the Section 1 statement. So they are the days of work that an employee is required to work, whether the working hours are variable and how that variation will be determined, any paid leave, so that's in addition to holiday and sickness, so things like maternity or family leave or any other type of leave. Details of all remuneration and benefits, so if there are contractual bonuses, if there's car allowance, that sort of stuff, that also needs to go into that document. Any probationary period and conditions relating to it. So typically contracts will say the first 3 or 6 months of your contract is a probationary period, in which either party will have an opportunity to assess the suitability of the other. And in the employer's case, they will consider performance, suitability, and in that probationary period, there will typically be a shorter notice period. So if they say, look, this isn't working for us, the employment's terminated, and you'll be terminated on 1 week's notice, for example, as opposed to 1 month. And any training which is mandatory and/or must be paid for by the individual. And it's important, and I think something that's often forgotten, is that even if there are no particulars of those items, the same should be stated. So if there is no probationary period, the Section 1 statement needs to say there is no probationary period applicable to this contract, or there are no additional benefits other than as provided for in this agreement, for example. Given the amount of information that's required, you might be thinking that this written statement is going to run several pages, but the statement can refer the employee to another source, such as a handbook, or often people use an intranet now, for certain information, including incapacity, i.e. sickness and sick pay, entitlement to other paid leave other than holiday, pension details, and any training entitlements. Plus, the Employment Rights Act also provides that some of the particulars can also be provided in a separate statement up to 2 months after the employment begins. So previously, there was a period of time in which an employee could start before they were required to be given a Section 1 statement. That changed in April 2020. It's now on or before day one of their employment or their engagement, so they need to receive that document, save for particular information that can be provided within 2 months. The follow-on document may cover details of pension schemes, collective agreements, any training entitlement, although compulsory training or those paid for by the employee needs to go in the original document, and any disciplinary and grievance procedures. It also should be taken into account that the Employment Rights Act also provides that changes must be notified in writing to the employee or worker within 1 month of the date of the change. So if an employee is given a promotion or a salary increase or anything like that, the update to the contract, that must be put in writing and provided within a month of that change. So then, how we go about identifying the terms of the contract. So we've got the express terms. Those that have been explicitly agreed between the parties, either orally or in writing. Even if there's one document that is purported to be the employment contract, it will often not contain the whole terms governing the employment relationship, because contractual terms may be derived from a variety of sources, and it's sometimes necessary to look at how the express terms have been operated in practice. i.e. there might be a contractual bonus scheme that sits outside, or there might be a handbook that has contractual terms that are set out, but there's additional, so they don't sit in the employment contract, but they remain express terms. We've also got implied terms, so they are terms that have not been specifically set out or stated by the parties at the time of entering into the contract. Indeed, the parties might not even address their mind to the issues covered by the implied terms at the time. So implied terms could be from the parties' intentions. The business efficiency test, i.e. would the contract make sense without the term, and the officious bystander test. So is the term so obviously in the contract that it goes without saying, as well as looking at the conduct of the parties after the contract is entered into. So an obvious implied term in a contract is the term of trust and confidence between the parties. So the employee trusts that the employer will do right by them and protect them and ensure their safety whilst working, for example, and the employee trusts the employee that they will work hard for them and they won't rob them, they won't place them in any issue of disrepute. There are also implied terms that could be implied by statute, so equal pay between men and women, and minimum notice periods under the Employment Rights Act. So just to briefly touch upon that, after an employee's been employed a month, they're entitled to at least a week's notice, and that increases by years employed. So after 2 years, you're entitled to 2 weeks notice. planning all the way up to 12 weeks or 12 years, after which the statutory notice period is capped. Now, in more senior contracts, you often see that minimum notice periods of 3 months, for example, or even as 6 or 12 months. So, and employment contracts can have longer notice, have contractual notice periods that are in excess of statutory notice periods, but they can't have contractual notice periods that are less than statute. So if the contract says your notice period is 4 weeks, either way, so either party must give 4 weeks to the other, 6 years down the line, as an easy example, then statutory notice would take precedence. They would say, I'm entitled to 6 weeks notice as per statute, and that trumps contractual notice. We also get an implied term referred to as custom and practice. So there's a bonus scheme that is paid every week for every year for every year that an employee's worked there, no discretion, no variation, and then one day an employer says we're going to change that. An employee might try and say, well, there's an implied contractual right to that bonus by custom and practice. Now, of course, when a court considers that, it will bear in mind that the custom and practice must be reasonable, notorious, and certain, and be followed because there is a sense of legal obligation to do so. Discussing incorporated terms. So, as I mentioned before, there might be terms that are incorporated from a handbook or the terms of a collective agreement. A collective agreement is not usually enforceable, but the terms of the collective agreement can bind a particular employer and employee if the wording of the individual contract of employment provides for incorporation and the particular term is apt for incorporation. So when assessing whether the parties intended a provision in a collective agreement to have contractual force, the main factors are the wording of the provision, the importance of that provision to the contractual working relationship between the parties and its relationship contractual arrangement between them, the level of detail prescribed by the provision, the certainty of what the provision requires, the context of the provision, and whether the provision is workable or would be if it were taken to have contractual status. So, rules of interpretation. So, contra preferentiam, the rule, or in other words, if in doubt, the writer loses out. So, where there is doubt about the meaning of the contract, the words will be construed against the person who put them forward. Case law suggests that this can either be the party who drafted the contract or else the party seeking to rely on the ambiguous clause. In the employment context, it will usually be the employee who's seeking to rely upon that rule. So it's pretty obvious that the employer, in 99% of cases, will draft the contract. So if they've not paid the right thought to what they mean by a clause, an employee is entitled to say, well, here's how I understood it to mean, and therefore that's what it means. So looking beyond the written contract, when a dispute arises in the employment context, the starting point for ascertaining the intention of the parties is usually the written contract. However, it may become necessary to look beyond it to the course of dealing between the parties and their subjective beliefs about what the obligations they've entered into. This might be because the written contract does not reflect the true intention of the parties, or it's a sham, or the parties did not intend the written document to be an exclusive record of the terms, or that the written documents are sparse and shed little light on the actual arrangement envisaged. The written contract will therefore only be the last word in interpretation when the parties made it clear that they intended the written document to be an exclusive record for their agreement. Whether they have done this is a question of fact, which will take into account all the surrounding circumstances, including other documents and communications. So drafting contracts then, and some examples of where it can go wrong. So the case of Aston and Webb's involved permanent health insurance cover. So essentially, it provides that after a period of time of sickness, this insurance product will kick in, and will pay an employee's salary or a percentage of an employee's salary for a certain period of time, and is typically used with senior management teams as a way to incentivize them and to bring those in. So this case highlights the dangers of the parties not making what they've agreed clearer when circumstances change. So Mr. Apton started employment without a written contract, so issue 1. 7 years later, his employer introduced a permanent health insurance scheme, which provided him with income protection until retirement in the event of critical illness. A year after that, Mr. Apton signed a written contract, but because the template employment contract that had been used had been drafted prior to the new scheme, it did not refer to the scheme or specifically incorporate it into it. So the employment contract provided Mr. Apton with an entitlement to 6 months' pay in the event of illness, at which point the employer would have the right to dismiss with contractual notice. When his employment was terminated during a period of serious illness, he challenged the dismissal as wrongful and as being in breach of the PHI scheme, as dismissal would deprive him of the benefit of that scheme. In light of the conflict between the scheme and the term of the employment contract, the High Court implied a term that Mr. Apton's employment would not be terminated if he might benefit from the scheme, holding that the parties had overlooked making this clear. So what you will often see in employment contracts now, and directly as a response to this, is a clause that says the employer will be entitled to employ the employee's employment, irrespective of whether this would deprive the employee of particular rights under one of these schemes. So in that scenario, it's expressly agreed that even if the PHI scheme is in place, the employment can be terminated.
Jordan, sorry to interrupt. Just to be sure, we're still on the first slide, right? Or you're changing the slides?
I am changing the slides. Has it not been showing?
No.
Does it show it now?
I don't see anything at the moment.
No, it's only you on the screen. No slides at all.
Thanks, Julia.
All right, let me try again.
Yeah, we see now drafting contracts when it goes wrong.
All right, so does this change now?
Yep, thank you.
Thanks, Jordan, sorry.
No problem. Apologies that you've had to listen to me whistle on for 35 minutes stuck on the same slide. Hopefully it'll be a bit more a bit better this time. So we're actually on slide 10 now, nearing the end. Some of you
can you please, when you click the next slide, just tell us that you're going to the next slide. Yes. So we were sure that it works this time.
Yeah, we'll do. And we can cut all this out for the YouTube, I'm sure. It'll look seamless for YouTube. So I was just going to then talk about the second case. So of Anderson and others and London Fire and Emergency Planning Authority. So in that, a collective agreement provided for 2 possible rates of pay with no indication as to which should take precedence. So the employer then elected to pay the lower rate, no shock. Construing the clause objectively, the Court of Appeal said that it's clear that the trade unions would not have agreed to a deal in which a rate of pay was covered by 2 alternatives, with the employer having an unfettered right to choose between them, and therefore said that it must be the higher rate, which was a costly error for the employer. The case of Vision Events in Patterson is another case that highlights potential consequences of not providing clarity in relation to key terms. This time, though, the employee lost out. So the employee had sought to recover £12,000 in salary for overtime. While the flexi-time scheme was clear that he should receive time off in lieu of any overtime worked, it did not provide for what would happen to the bank's overtime on him leaving. the EAT refused to imply a term that the employee would be paid for it. Right, I've just changed slides. Does everyone see that?
No, it's still the previous one, Jordan.
Yes.
This time?
No.
I think it's if I use the keyboard, it doesn't seem to like it. Right, can everyone see clauses that favour employers?
No. No slides at all.
No slides at all.
Yes.
Yep. Great. Okay. So, I want to now discuss a couple of optional clauses that are often used and are favourable to employers, so ones to look out for. So, the first one is the entire agreement clause. So, one way in which arguments about inconsistencies can sometimes be avoided is to include a provision that makes clear that the contract prevails in the event of inconsistency, or alternatively, an entire agreement clause. This provides that the written agreement constitutes the entire agreement between the parties and that no contractual terms are to be found elsewhere. However, it won't always avoid disputes about contractual interpretation, as terms may be implied in any event, as we've seen. So, you will often see in employee handbooks, so employee handbooks are the big sort of optional extras where they'll have all the different types of policies and things like that and procedures. It will often say in there that to the extent that the handbook is inconsistent with the contract will take precedence. And similarly, the entire agreement clause will often say this document supersedes and extinguishes any previous agreement and shall take precedence in the case of any argument. So one to factor in, but of course the point in implied terms is if any of the implied parts apply, then the entire agreement clause isn't sort of perfect. We've also got sort of flexibility clauses. So when drafting an employment contract, it's often in the employer's interest to incorporate as much flexibility as possible. This will be particularly important if there is a bonus included. So they might consider whether there is any discretion as to whether the employee will be considered for a bonus, or whether the discretion applies only to the amount of the bonus to be awarded. If it's just that the amount's discretionary, then what other factors will the employee take into account? If it's performance, how will that be measured? And will overall company results impact this? A clause that sets out any entitlement is subject to the employer's absolute discretion, will give the greatest flexibility, again, subject to any implied terms. So you will see in any case of bonuses and things like this, it will say subject solely to the board or the company's discretion, you may be eligible to receive X or participate in Y bonus scheme. So that then makes quite clear it is not a contractual term and may be varied or amended. Now, employers should be wary of the fact that if they say they've got discretion but never ever exercise that discretion, then an employee might be entitled to say, well, actually, via custom and practice, it's not perfect. It might not always work, but an employee might say, I think I've got an applied right to that bonus via custom and practice because I've always had it and it's never been varied or rescinded. And then clauses concerning termination then. So the contract should set out the extent of the employee's entitlements and obligations upon termination. In relation to entitlements, the clause should identify whether a right to any bonus payment will remain after notice has been given. Bonus clauses may sometimes differentiate between the circumstance in which an employment relationship might end and might provide bonuses to be payable to good leavers. And there might also be ways of describing a good leaver. So sometimes it might be that if the employee's employment is terminated due to redundancy or purchased by a different business, then they will be paid. But if they leave, if they resign of their own choice, or if they're dismissed for gross misconduct or even any misconduct, then any bonus that is about to be paid or could be paid won't be. Sometimes it will be an employee who leaves and subsequent than resignation or gross misconduct dismissal. In other cases, good leavers will be leaving for ill health, redundancy, or retirement. In relation to obligations, the contract should set out any post-termination restrictions in relation to confidentiality and the employee competing with the employer. These restrictions will only be enforceable insofar as reasonably necessary to protect the employer's legitimate interests. So the shorter the period and the narrower the restrictions, the more likely it will be to be valid. So the starting point with restrictive covenants is that they are a restraint of trade, and they are unlawful unless we can show that we genuinely need them and we haven't been unreasonable, we haven't stopped the employee working in the whole country or for a year when the business cycle changes every 3 months, for example. So it should be, those types of things all need to be considered. And then last but not least, layoff and short-time working. So this is a particular form of flexibility clause, historically prevalent in construction and in industries where work tends to fluctuate. Although recessions and, of course, the COVID-19 pandemic have highlighted the possible advantages of wide usage, as companies try to find ways to reduce costs in a downturn without permanently losing skilled staff through redundancy. And you won't be able to see it, but the next slide says any questions. So I'll not waste anybody's time showing that one screen for the one word. So I appreciate I've rattled on for some 42 minutes. So I'm grateful you're all still here, and hopefully it was of some value. I don't think we've had any questions yet, and I don't want to deprive anyone of the opportunity. So if anyone does have a question, please let me know.
Dear participants, do you have any question? If not, then I'll just start my list. Okay, then as always, the list of my questions. Well, first of all, Jordan, thanks so much for this precise presentation. As you know, I had much more questions on these yellow papers, but when you were talking, and without slides, but at least, you were talking about cases, I had to withdraw the questions. So my first question is, well, thanks so much for telling that it's possible to not to have the written agreement, but it is possible to have oral agreement as well. But just we need to have a statement if we don't have signed written agreement. But in this case, at least in any way, if let's say there are some stations like people need to work, refugees trying to look for a job, and there are situations when the employer says, okay, you take it or leave it, or you don't take it, right? So in these situations, they provide the template of the contract, and you're not in the position to negotiate on the provisions of that contract. So my question is, can you give recommendations on what essential provisions should be in the contract that Ukrainian refugees are not in the situation when they are just fooled?
Yeah, of course. Well, I think it goes back to, so in April 2020, when the additional Section 1 particulars came in, it was all about Taylor's good work plan. So the headline term was that an employee should know what they're signing up to beforehand. There shouldn't be any surprises. So ideally, if an employer has provided a Section 1 statement, I think the employee, more than anything else, being pragmatic, needs to know exactly what the deal is. So they need to know when they're working, how they're working, days, what it is they're being employed to do, how much they're going to get paid, when they're going to get paid, if they need to take annual leave, how do they do it and what do they get, if they're unwell, how do they do it, and I think it's about transparency. It's difficult, isn't it? Because I suppose you might say, well, taking any offer in certain circumstances is better than taking the best offer, but I don't know many employees that really ever get an opportunity to say, right, thanks very much for that contract. Here it is in it with a red pen. I'll sign this one. I think that would be very. You would be incredibly fortunate to be in that position. But I think as long as, and I think most employers, certainly the employers that I work with, do provide Section 1 statements. I think as long as the refugees know what they're signing up to and know what the deal is on the table, then I think that's the best position they can find themselves in.
Okay, and if the contract, if we can't write down the contract, like all the precise provision in it, so how inner rules that the employer has, how they will be adapted to this employment contract or take into account if there is any dispute?
Yeah, so, and that's a fair question because, an employee might say, well, you promised me this, and the employer says, no, we didn't.
Yeah, for example, the bonus. For example, if we negotiate with you that you will give me a bonus and there is nothing written down in the procedure, not the procedure, but in the employment contract. And then when I leave the company and I don't see this bonus, then this is the question, why you don't pay me this bonus?
Yeah.
And the answer from the employer, because nothing is written down in your employment agreement.
Yeah, and I suppose in the first instance, well, one thing is going back to the slides, because it's typically the employer that offers or writes the contract, or in any other case, then to the extent that the bonus is ambiguous, or if the employer says, look, I accept there is a bonus, but I say if you leave then you don't get it, then the employee is entitled to say, well, you didn't say that, you've not written that down anywhere. I guess it's difficult. It depends on the scenario. So I would probably just recommend that both parties make a note of what's been agreed, so that when it comes to it, hopefully it's not the case, but if it comes to it, say, well, no, when we were chatting, I wrote down the elements and I made clear when I offered that bonus to the employee, it was discretionary, and if I had to change it, I would. If it had to get there, then the UK has what's called the Employment Tribunal, so a specific labour court for these types of disputes. And either party would have to give evidence. They'd have to say, I met with so-and-so on this day and this is what was agreed. And ultimately, if each party is saying something different, then it will fundamentally come down to who the judge or the judge and panel believes. So having some form of evidence and being a credible witness, it goes a long way.
So, for example, even if something is not written down in the employment agreement, but before signing this employment agreement, the person can just write an email saying that, hey, this is what we agreed, right? And make the list of these questions that the parties agreed.
Yeah. So a contract can be oral or written, and it does sometimes happen where they don't have contracts, and then it goes to, well, what actually happened in practice. So if there's a dispute about hours of work, for example, they can say, okay, well, in the last 12 weeks when you were working, let's assume they've been working 12 weeks, and say, well, what hours did you work? Well, I work 9 till 5, Monday to Friday every day. Then it's probably going to be taken that the contractual hours are 9 till 5, Monday to Friday. If actually the opening conversation was, well, look, you need to work 40 hours a week, but Monday to Sunday, and it'll depend each week, then the employer might be in a position to say, well, I made it quite clear that you would work 40 hours, but they would vary across the 7 days. So it's just about clearly understanding, and that's the purpose of the Section 1 statement, is so that the parties both know precisely what is being provided to the other party.
If there is engagement letter and there is employment contract, so if something contradicts to each other, what should prevail? Or it's the matter of dispute and providing evidences in the court?
Yeah, well, it's tricky. I mean, if there is an entire agreement clause in the contract that says, in the event of a dispute between any other document, this one takes precedence, then it'll typically be the contract. It might be that if there is a bonus process or procedure or letter, some employers will provide a yearly bonus letter and say, here are your targets for the year, and if you hit your targets, here's what happens. It might say in there expressly that this isn't contractual, and in the event of any dispute, your contract takes precedence. So that's one way that it's typically done. Or yeah, the court might be entitled to imply that a particular contract takes precedence over the other if it was super obvious. For example, if an employee was offered a minimum wage salary and £100,000 bonus per year, and it was so plainly obvious to the parties that the core element of that contract was the bonus, then later trying to say, well, the bonus was discretionary, actually we've just got this person on minimum wage, then I think a court's entitled probably to say, well, actually, no, the bonus takes precedence because that's clearly that's the meat of the contract.
My last question, I promise. So I do understand that if or when you sign the contract, and if something's changed, as you said, we need to conclude additional agreement to this. But if there is no employment contract, but there is statement, and something is changed, do you understand right that employers have to provide additional statement if some conditions are changed?
Yeah, that's right. So yeah, it's called a statement of change. Particular clause. It says it specifically in the Employment Rights Act that yeah, within a month it should be written down. So that's why often employers, there'll be an annual pay review, and then within a month you'll get a letter saying congratulations or whatever it might say to begin with, but it will say your salary from X date is now X, X number, and that's typically why it's done, because those changes ought to be recorded in writing. The actual effect is quite minimal. So to give a similar example, an employment contract needs to be provided, but if it isn't, then the most that a court could do would be to provide the employee with 2 or 4 weeks pay, and that type of claim can only be brought on top of a substantive claim such as unfair dismissal or discrimination. So they couldn't go to the tribunal and say, I haven't been given a contract, could I have 2 to 4 weeks pay, please? But they could say, I was unfairly dismissed, and by the way, I wasn't provided with a contract on time or at all, so I'd also like an award of 4 weeks pay or 2 weeks pay for that.
Thank you so much. Dear participants, do you have any other questions? Or maybe you want to share any practice, or maybe you want to share any cases from Ukrainian law? No.
Hi, yes, actually, I have one question. Thank you, Jordan, for a very informative webinar. That was very useful for us. I just want to ask about fixed term contract. Is it the kind of employment contract, or it's totally different, and how it works there? How is it possible to change some conditions? Do we need to do the same procedure, like additional agreement to this contract? Is it like different regulated act for this type of contracts? How it's maybe I missed something. Sorry. If yes, just could you please confirm that it's the same or different type? Thank you.
Yeah, no problem. Good question. So the section 1 of the employment, so the section 1 statement must say whether the contract is indefinite or fixed term. So it must explain when the end date is, and it's good practice also to say the reason for the fixed term. So if it's to cover somebody on long-term sickness or some form of parental leave, or if it's to provide a particular project, then that it's always good practice that goes in there. There are particular sort of protections for fixed term employees, things like not being mistreated, and also that I think if you have successive fixed term contracts that go beyond 4 years, then unless there is a reason why they ought to continue to be extended as fixed term, then it could be construed that the contract then becomes permanent. But yeah, typically if it's fixed term, there will be something in the commencement and duration section of the employment contract that says the employment will begin, will run from X date until Y date, when it is terminated either upon notice or without the requirement for further notice.
I see. Thank you so much. And also, what I wanted to realize, if, for example, we have a choice, just put it like a special term in the contract, or just make it without any term. Is there any like protection for us as employees to put their special term, or just it's better to leave it as it without any termination? Is it different or not in the UK? Thank you.
No, it's not. Well, as mentioned, obviously the employer is the person that will write the contract. So if they later want to say it was for a fixed term but didn't put it in the contract, and the contract says it was indefinite, then that ends up being a problem for the employer, because they've got to then say, no, actually we only meant for the contract to be 2 years, for example. If you get to 2 years in a day and you say, well, no one told me it was fixed term, or my contract says I'm here for the long run, then actually my advice to employers and employees would be just make sure it's written down, and there's no it avoids the dispute later on. But typically, yeah, it will favour the employee if the employers forgot to mention that the contract's only for a fixed term.
Thank you. And also, if it's possible, I have one more question about payments. Is it common practice in the United Kingdom that you can put in the contract exactly your hour rate? So, for example, just say that, like, for example, I don't know, 20 pounds per hour. Basically, this is like a salary, or just only, for example, then 40-50 thousand per annum, and then you realize that you can calculate your hour rate. Because I've never actually used. I have like 2 contracts for now, and it's like just my annual salary. But for me, when I'm looking for new positions, I see that there are a lot of possibilities just to receive it like with using hour rate. So it's interesting for me how it actually you can fix it in your contract. Thank you.
Yeah, I mean, it tends to be whether or not the employee is working full-time hours. So if somebody works 40 hours a week regularly, then there will be a salary, because salaries are based on full-time hours. If you're going to work part-time hours or variable hours, i.e. one week you might work 30 hours, the next week you might work 10, then obviously a salary doesn't work, because it changes. Unless you regularly, you average out to work the same. So it tends to be whether somebody works regular hours or not. So just bear that in mind.
Got it. Thank you so much.
No problem.
Well, maybe someone else has questions. Well, okay, if not, then Jordan, thanks again so much for attending our UBLN Academy, for presenting this wonderful topic and being so precise on the information and answering all our questions. Dear participants, and I'm inviting you the next time for our next webinar that's going to be about the rights of employees. Please follow up our LinkedIn page and see the agenda. Thank you so much and see you again at UBLN Academy.
Thank you, Jordan. Thank you, Rina. Have a nice day. Thanks.
Thank you.